right. Good evening. Good evening to everyone here tonight, and good evening to those who are now joining the live stream. Welcome to this public consultation on the amendment to the Trades, Businesses, Occupations, and Professions Licensing Act. I acknowledge the presence of my permanent secretary, Mrs. Chanel Pettit-Barrett, Ms. Shama Hodge, Commerce Officer, and I welcome the Acting Premier, the Honorable Hayden Hughes, and Karen from the Chamber of Commerce. And I see we have Mr. Kentish, and I forgot your name, but I'm just saying hello to everyone. Welcome to this session. I once again want to apologize for the late notice of this amendment. We have to move quickly sometimes in government, and this is something that we're trying to avoid as it relates to being blacklisted by the EU. So we're here to make a kind of simple amendment, and we're here to hear from the public as well as it relates to this amendment. So without further ado, we have Marissa Harden Hodge, Principal Assistant Secretary in the Ministry of Finance. She's going to go through this bill, and I thank her for being here as well. Thank you.
Thank you, Minister, for the introduction. I will just jump right in. Noting the time, and I don't want to keep us long. It's a very short proposed amendment to the Trade, Business, Occupations, Professions Licensing Act. As some of you may be aware, that act is currently under review, and it's proposed to do a significant overhaul to the business licensing regime, which will ultimately result in a repeal and replace legislation. So it will be significantly overhauled. However, this proposed interim amendment addresses a particular concern of some of our international partners to which the government of Anguilla has committed to adopting and transposing within its legislative framework the proposed amendments to ensure compliance with certain fair taxation and tax transparency standards. So I'll jump right in. The primary purpose of the amendment to the Trade, I'll just call it Business Licensing Act for short, is in order to implement restrictions on the conduct of relevant activity by general partnerships. So what is the amendment? What are substantial activities? What are relevant activities? So the EU would have developed a screening process in about 2016, which has screened a variety of third-party jurisdictions on a set of good governance criteria and criteria related to transparency and fair taxation. Part of this criteria, which was criteria 2.2, required that jurisdictions should not facilitate offshore arrangements which do not reflect real economic activity in the jurisdiction. Now, real economic activity relates to the nature of activity that benefits from the tax regime in the jurisdiction. The substantial economic presence relates to the factual manifestation of the activity that benefits from the tax regime. So it's all about when you're doing business in a jurisdiction, or when you have the benefit, when say you're a company and you're flying the Anguilla flag and claiming that you're an Anguilla company and therefore you're taxed in Anguilla. So you're saying you're tax resident in Anguilla, you should be conducting real economic activity. You should have physical presence in Anguilla, actual economic activity in Anguilla to get that tax benefit, which in our case is zero tax in relation to corporate income tax. So that's what this tax transparency criterion is about. So jurisdictions such as Anguilla must be able to evidence and enforce legal entities, arrangements, and other undertakings in their jurisdiction have relevant economic substance in relation to relevant activities. Now, relevant activity isn't any activity. It's a specific subset of geographic, what is deemed geographically mobile activities where tax arbitrage, and there is potential for persons to seek to get tax benefits from where they're not actually conducting relevant activities. Now, Anguilla would have made some commitments to the EU to implement into law the substantial activities requirements in 2017. Anguilla was given some temporary reprieve due to Hurricane Irma in 2017, but in 2018 they were required to effect those legislative amendments to ensure that legal entities in Anguilla had appropriate substance, and that legislation was to come into effect for January 1, 2019. So Anguilla would have implemented the substantial activities requirement in 2018 in relation to Anguillan companies. Now, Anguillan companies, when I refer to Anguillan companies, I mean entities formed under the laws of Anguilla, which we have companies formed under the Companies Act, companies formed under the Limited Liabilities Companies Act, companies formed under International Business Companies Act, and companies formed under the General Partnerships Act. So that legislation already has the substantial activities requirements attached to it, which means that when companies formed under that legislation are doing business, they must file certain returns to the Registry of Companies to show that in relation to the activities that they conduct, that they have substance in Anguilla. And substance in Anguilla is stuff like you have enough staff in Anguilla, you have appropriate expenditure linked to your activities, which is whether it be on electricity, rent, staffing, and then also there's provisions relating to mind and management, where the operations are overseen and where the meetings take place of management, where there's a quorum, etc. But that's delving into that further. It's not relevant for this amendment because it's not proposed to transfer that substantial activities framework through this legal amendment. But to backtrack a bit, I wanted to discuss what relevant activities are. Now, relevant activities, as I mentioned before, are linked to geographically mobile activities which form under the FHTP standard. Now, the FHTP is an OECD body known as the Forum on Harmful Tax Practices. So they're an independent international body which sets certain standards in relation to tax. So relevant activities. Relevant activities are banking, insurance, fund management, financing and leasing, distribution and service center business, shipping business, holding intellectual property as a principal asset, headquarters, holding company business. Now, I've highlighted 3 of them in red, and that is because they do not fall under the scope of this amendment to the Business Licensing Act, because those activities aren't licensed under that act. Banking is licensed under the Banking Act and the Trust Companies and Offshore Banking Act. Insurance business is licensed under the Insurance Act, and holding company business is not licensed. Holding company business relates to you actually being a legal entity, and if you're a legal entity, you aren't a general partnership. So, because this amendment is specifically targeting at general partnerships. Now, I'll delve into that a little bit more. So, partnerships. In Anguilla, we have 2 types of partnerships. We have general partnerships, which are governed by the Partnerships Act, and we have limited partnerships, which are governed by the Limited Partnerships Act. Now, limited partnerships are registered. That means if you want to be a limited partnership, you need to go to a corporate service provider, and they will log on to the Anguilla Commercial Online Registration Network, ACORN, and they will register your limited partnerships. As I mentioned earlier, limited partnerships are already fall in scope of the substantial activities requirement. That means in 2018, the Limited Partnerships Act was amended to require limited partnerships conducting relevant activities to have substantial to have substance. Therefore, limited partnerships are not under concern of the EU because they're already covered by the standard which the EU has set. General partnerships, however, are not covered by the substantial activities framework. The EU did review Anguilla's general partnerships framework, and they did have concerns. Specifically, the EU member states concluded that Anguilla's legislation does not cover all the appropriate categories of partnerships. They noted that Anguilla should amend its existing economic substance legislation and framework to include general partnerships in the scope of economic substance requirements. Now, there is some general partnerships are distinct from limited partnerships. So, as I mentioned, limited partnerships are registered. General partnerships are not registered in Anguilla. There is no constitutional documents issued by Anguilla, be it the commercial registry or any other entity. Partnerships under the Partnership Act is defined in Section 3 as the relation that subsists between persons carrying on a business in common with a view to profit. These partnerships are neither incorporated nor registered under this Act, but are governed by the rules of equity and common law. The persons carrying on a business in common have the persons are carrying on business in common, or they have a partnership agreement which buttresses the existence of the partnerships. So because of this structure, because they're not registered, because we don't have a list of them, it would be difficult to apply the substantial activity requirements that companies in Anguilla have, because that process requires you to be on a list with the registrar, for you to file a return through the registry's electronic system, which is built specifically for companies that it registers. So there will be no module that can capture general partnerships on that system. So the proposed amendments, instead of transposing the substantial activity requirements to the Partnerships Act, which there's no parallel between the Partnerships Act and the company formation legislation, which would allow for such transposition, we're proposing to amend the business licensing framework to prohibit general partnerships from conducting relevant activities. Now, the reason is general partnerships are allowed to apply for business licenses. In some jurisdictions, you have to be a legal person to be licensed, BVI in particular. So you either have to license as an individual or you license as a legal person. In Anguilla, we can have 2 or more persons licensing as individuals without having to form a legal structure to be issued a license. That is the reason why the EU have certain concerns with respect of general partnerships' ability to conduct relevant activity. Now, the proposed amendment will prohibit issuances of licenses to do business in Anguilla to unregistered partnerships. That means general partnerships. So you could conduct relevant activity as a limited partnership. You could conduct relevant activity as an individual. You can conduct relevant activity as a company, but not as a general partnership. So not 2 or more persons unregistered getting a license. The provision will require persons to be registered as a company or limited partnership to be issued a license to conduct relevant activities as outlined above in respect of activities licensing under this Act when they are 2 or more persons. The draft bill would have been previously sent out to consultation, and it's a very short bill. And these are, again, the sections of relevant activities. That's basically my presentation, and I guess I open the floor for questions.
here. You want to come here? Do you mind?
If you have a general partnership with a national mortgage listing number,
With a what?
a national mortgage listing number, to be able to do business in the Caribbean as well as in the United States, would you be able to do business under that framework?
I'm not understanding what is a national. I'm wondering if my colleagues understand what this is.
It's a U.S.
Have you been issued a license by the Inland Revenue Department, the Ministry of Economic Development?
No. But what I'm asking...
Okay, so this amendment pertains to the Business Licensing Act. So you'll be impacted if you're licensed under that act. Are you licensed under that act?
No.
Okay. Someone sent me a question via WhatsApp. Any particular reason it's being imposed on Anguillians in addition to non-Anguillians? I figured the non-Anguillian aspect would satisfy the EU economic substance requirement. So the person is just curious as to why it's being imposed on Anguillians in addition to non-Anguillians.
So in relation to this standard, this EU standard, the concern was in relation to resident versus non-resident, which is distinct from Anguillan versus non-Anguillan, if that's clear. So as I should add that this proposed amendment was went through several rounds of review by the EU before it was basically given the I won't say approval because it still needs to be approved by the EU ministers, but the EU technical team had no further concerns in relation to the proposed amendment. So we anticipate acceptance of the legislation once it is enacted, and the EU have given an indicative deadline of 30th of June, which is what, Wednesday?
Do we have any questions from the acting premier? Okay, I have a question that can probably lead to an explanation. Was it also required of the BVI to amend their legislation, or they already had the proper legislation in place?
So from interfacing with my colleagues in the BVI, it's my understanding that they were not requested to amend their partnerships legislation in respect to general partnerships, because their legal framework did not arise any concerns in that respect because of how their licensing regime works, because that they require, when two or more persons are conducting business, for them to be either a legal entity or a legal arrangement, which is not a feature of the Anguilla's licensing regime. So Anguilla's proposed amendment does mimic that feature, however, it's more limited now to the relevant activities, conduct of relevant activities, whereas in the BVI case, it refers to conduct of all types of business activities.
Okay.
So this applies to partnerships, but not sole proprietorships. And what would be the risk? Like, I could see a risk with both, but why are they targeting the partnerships at this time? As opposed to everybody has to meet this requirement.
this is what they're targeting. So in relation to sole proprietorships, so there's two standards, let's call it two standards. There's the FHTP standard, which is the international body, and then there's the EU, which is the group of member states. So the EU's framework is somewhat pays homage to the FHTP standard, but they have their own criterion, which must be followed by persons. Otherwise, there's a risk of persons, jurisdictions being deemed non-cooperative tax jurisdictions and listed on Annex 1, which is the blacklist, colloquially known as the blacklist. So under the FHTP standard, general partnerships aren't relevant. So this wouldn't be an issue for their standard. And sole proprietorships aren't relevant. They do not see the risk in either. The EU has seen a risk, deemed a risk, and they have required Anguilla to address this risk. So that, I understand I haven't fully answered your question. I've told you that they've seen a risk. I've told you they've seen a risk, and I've told you the FHTP doesn't see a risk. But they've seen a risk, and we are required to address the risk, or we will be listed by the EU member states.
Do we have any questions online? I haven't seen any. Okay. Any more questions from the gallery? What I could also add is that we are about to introduce the new framework that governs the trades, businesses, occupations, and professions licensing act. And in that new document, we are also requiring local businesses to, once it's a partnership, to have some type of cooperation registration taking place. This is necessary to avoid what we call fronting, and just generally to increase business transparency. So in the new business license framework that will be implemented in July, I think it's the I don't remember the date, but sometime in July, that new legislation will come into effect, and it will also cover this amendment. If we don't have any more questions, then we can bring this to a close. And tomorrow we are going to the House, and we'll be doing the second and the third reading. And I just want to thank Marissa for her hard work, and thank the PS and the other technical staff for putting this together quickly to avoid Anguilla being blacklisted on the international scene. So if we have no more questions, then I can bring this to a close. All right, so thank you so much for coming out, and thank you for joining in online. I don't see any questions online, so I think that's a wrap for us here tonight. Thank you and good night.